Let us examine our position. There are two accused persons who have been indicted and are aware of the charges for over a year and a half. They have never attended court to answer to the charges, and this despite numerous accommodation by the court. And to add, there have been promises from the bar to have them attend court, all amounting to naught. I am convinced that the orders granted stand on solid legal foundation. I decline the invitation to stay the orders. I will, however, direct that the proceedings herein be typed in haste and copies granted to the defense on priority basis for purposes of filing the intended appeal. This matter will be mentioned on 28th of July as earlier directed. I had directed that the counsel for the defense produce the two accused persons in court on the 17th December 2025. This did not happen. Mr. Boajo, learned prosecution counsel, has insisted that there are no instructions barring him from proceeding. He sought that warrants of arrest do issue. Mr. Njage promised you a charge. You are either presented in court in the case of a cognizable offense, or you are summoned to appear for plea even when you are out on some bail or bond, whether granted by a court or the investigating agencies, including police. These two accused persons face serious charges. They have been aware of these charges since early November 2024. That they have never presented themselves to court to date is a sign that they have ignored the jurisdiction of this court. The presence of their counsel, however frequent, is insufficient. They ought to be here. All their promises made on their behalf by their counsel have all been barren. I'm in agreement with the prosecution that the court must assert its authority. I will now issue warrants for the arrest of the two accused persons who, for the record, I had asked to appear either in person or virtually to take this ruling. The prosecution is at liberty to kickstart extradition proceedings in that behalf. This matter will now be mentioned. I had suggested 28th of July.
Your Honor, the mere fact that there is intention to appeal or review or apply for revision for the orders that have been issued by this court today, in itself, the intention is not a sufficient ground to warrant this court to grant a stay of orders of a matter that has been pending before this court for over a year plus. This court has afforded the parties that are now seeking the stay of the very orders that you've issued sufficient time to be able to avail themselves and to surrender to the jurisdiction of the court. And therefore, Your Honor, we find no reason why the parties in this matter making this application for stay should be allowed to benefit. And therefore, by allowing the sought 45 days of stay, it will amount to continue to perpetuate the same delay that has occasioned this matter to reach this stage without any meaningful progress. It is therefore, Your Honor, that the position of the prosecution that this court does not interfere with its orders of the warrant that has been issued. That having been said and done, nothing stops the applicant from moving the High Court. For Your Honor, it's our position, and we sustain the position that this court should not interfere with an order that it has just given, in order for us to allow this matter to have a meaningful progress.
Good. I have instructions to seek for stay of execution of that ruling for 45 days in order for me to seek instructions on appeal or revision of the same from the High Court. Apply for certified copies of the proceedings and ruling. To enable the defense proceed expeditiously. His accused constitutional right to launch a civil appeal. Secondly, we submit that no prejudice will be visited upon either party. Therefore, we shall be doing that stay to be granted.
Where is the second party? Sorry, just 1 second. Let me.
The only person who applied for review is the
Alice Moya?
I'm here.